Senator Umu Verbetten, thank you for presenting Senate File 73 today. And I guess, you know, what we might do quickly is ask our committee counsel, legal counsel, to just quickly go through the jurisdiction, just to reinforce specifically what we're going to be talking about in regard to this bill here today in labor.
Thank you, Madam Chair and members. I think in your packets there is a table or a chart that lists the provisions in the bill that are under the jurisdiction of the Labor Committee. And then there are some other provisions that might be under the larger provision is under the primary of another committee, but there are some concepts within those provisions that are concepts that are germane to the Labor Committee. So if you in Article 1 of the bill, section, so these provisions that I see as under purview of another committee, but again, there are concepts that are under the purview of this committee. So for example, in the definitions, there are a couple of definitions that are related to labor organizations and labor peace agreements. And then in Section 3 in Article 1, it establishes the Cannabis Advisory Council, and I wanted to note that the Commissioner of Labor and Industry is a member on that council or a designee of the commissioner. And then in Section 14, it sets up the what is required for a license application, and in there are the references to information about labor peace agreements and labor organizations that I know they've been discussed in other committees as well. Then also in Article 1, Section 2, Subdivision 5, the current cannabis program is being repealed but codified into this new Section 52 is part of that. So the particular subdivision it provides the protections for employees that are enrolled in the patient registry program. It is quite similar to what the protections are that are already provided under the current medical cannabis registry program with a few modifications. Then in Article 6, this is really where I identified the primary jurisdiction of this bill for this committee. Section 21 in the 6th engrossment. This modifies the lawful consumable products statute, and it adds cannabis to that list of lawful consumable products that an employee can consume those off-site of their employment, and then they are still protected as long as they're not consuming the lawful consumable product at the workplace. Then sections 22 to 34, all of these sections modify in some way some definitions or other parts that are particular to drug testing in the workplace. Basically, they're adding cannabis and or making some other modification to the existing drug and alcohol testing in the workplace provisions. And then finally, in Article 9, there is I believe it's still a blank appropriation, an appropriation to the Department of Labor and Industry for occupational competency standards and technical assistance for developing dual training programs by the Department of Labor and Industry. And that is the jurisdiction for this bill in this committee.
Thank you very much for that overview. We appreciate it very much. Senator Umu Verbetten, would you like to just give us a brief introduction of the bill before we go to testifiers?
Yes, thank you, Madam Chair, and thank you so much, Council, for walking through the jurisdiction. And I just want to give a huge shout out to our staff who've been working really hard to get the latest engrossments and get all these amendments. They've been doing a tremendous job. So thank you so much for all of your hard work. I will just give you a sort of an overview of the bill and then tell you, why it's important to me and why I'm a co-author. So this bill is about allowing adults to safely and responsibly use cannabis. It creates a regulated marketplace that is much safer than our current underground illicit marketplace. It automatically expunges petty misdemeanor and misdemeanor cannabis convictions. It establishes Cannabis Expungement Board to review higher charges like felonies or resentencing. It sets up grants, loans, and assistance for small businesses and individuals who enter the cannabis industry. And it provides funding for public health awareness, youth access prevention, and substance abuse addiction and treatment, including treatment courts. I really care about this bill because of expungement and because of the fact that cannabis prohibition has caused immense harm in our communities in the criminal justice system. Black Minnesotans and white Minnesotans consume cannabis at very similar rates, yet Black Minnesotans are 5 times more likely to be arrested for possessing cannabis. When we legalize, there's this responsibility to have expungement and to clear those records. The other thing that's really important about this bill is making sure that the benefits of legalizing cannabis go towards those who were most harmed by cannabis prohibition. So it's ensuring that they get to participate in the new regulated market, and this bill really lays out the ways to give folks that preference. So for me, it's about repairing harm, righting those wrongs, and addressing the racial injustice. That's why I'm proud to be a co-author of the bill. And again, thank you for walking through the jurisdiction for the Labor Committee, and our testifiers are going to be able to speak more directly to that as well.
Very good. All right, we'll go to testimony then. First up, signed up to testify, we have on Zoom, Robert Lopez. Mr. Lopez, hear us?
Yes, I can. Can you hear me?
Yes, and we can see you. If you would introduce yourself and any affiliation you'd like for the record, and then we look forward to hearing your testimony.
Thank you. Good afternoon, Chair McEwen and members of the Labor Committee. My name is Robert Lopez, and I'm a legislative representative with the United Food and Commercial Workers International Union. In my role, I monitor and analyze legislation in 26 different states, work with locals across the country to advance legislative priorities and defend against policies that hurt UFCW members and working families. UFCW Local 1189, which represents 8,000 members in Minnesota, supports SF 73, and I encourage members of the committee to vote in favor of its passage today. Requiring a labor peace agreement, also referred to as an LPA, as a condition of licensure and renewal, protects the state's proprietary interests, provides family-sustaining jobs for workers, and ensures a safe, quality product for consumers. LPA does not mean unionization. Workers are wholly free to reject the union, and they do sometimes even with these agreements in place. It simply just levels the playing field. The LPA requirement is very small and narrow. Companies are not required to agree to anything else with the union, and both parties negotiate the specifics of these agreements. The UFCW represents cannabis workers in several different states and have signed a wide variety of LPAs. Labor peace agreements exist in other state cannabis laws. California, Connecticut, New Jersey, New York, and Rhode Island all require cannabis operators to sign LPAs. Pennsylvania and Illinois incentivize operators with a merit-based system that gives points for LPAs. The emerging cannabis industry is a job generator. The work unions have done on behalf of workers in the state of Minnesota has led to a culture that values organized labor and not ending on the right to organize free of labor peace agreements reinforce that, allow workers to collectively bargain for higher wages and create safer workplaces. Workers face many health and safety risks in this emerging industry, from the exposure to abnormal heat levels, chemicals, and burdensome tasks that after long-term exposure to injuries on the job. Labor peace agreements would secure safe working conditions and protect the health and well-being of workers and consumers. The state of Minnesota already requires licensees in other industries to enter into private contract as a condition of licensure. An example here is the construction trade. However, the cannabis industry does not compare to other industries since the federal government does not recognize it as legitimate. This leaves workers without recourse and representation when licensees that are bad actors and LPAs can resolve that. In conclusion, the Minnesota cannabis industry presents an unparalleled opportunity to build a new kind of industry for Minnesota, one that recognizes the importance unions play and gives workers an opportunity to exercise workplace democracy to improve both the industry and Minnesota communities. Thank you for the opportunity to speak to you today virtually on this very important issue to the UFCW International and Local 1189. Thank you.
Thank you, Mr. Lopez, for your testimony. Next, we have Rachel Atkinson. And after Ms. Atkinson, we have Rihanna Buckles. If Ms. Buckles could also come out, and then we'll just do both of these in a row. Welcome, Ms. Atkinson, to the Senate Labor Committee. If you could introduce yourself and any affiliation for the record, we look forward to your testimony.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Rachel Atkinson. I'm a patient care coordinator at Vero Health, one of Minnesota's medical cannabis providers, and a proud union member of UFCW Local 1189. I'm here today to lend my support for Senate File 73, authorizing adult use cannabis, and specifically the labor peace provisions contained in the bill. I've been employed for the past 7 years at Vero in various positions, including packaging technician, and most recently as a patient care coordinator, assisting medical cannabis patients to ensure their experience is positive and beneficial to their health concerns. I also serve as a union steward. I work to ensure state regulations around medical cannabis are followed during that process. As a result of a labor peace agreement, we were able to organize free from interference from either party. The company was not hostile towards worker interests, and workers were not hostile toward the company. This was a decision made by us, the workers. We organized and collectively bargained to professionalize the cannabis industry and our workplace. We have a worker safety committee that meets regularly to also enjoy good benefits and retirement benefits. The labor peace agreement benefits and the employer by ensuring that the decision is up to us, the workers. Thank you for allowing me to speak today. I encourage you to support Senate 3.
Thank you for your testimony. And Ms. Buckles, welcome to the Senate Labor Committee. If you would introduce yourself and look forward to your testimony.
Thank you so much, Chair McEwen and members of the committee. My name is Rihanna K. Buckles, and I am the Legislative and Coalitions Director for Americans for Prosperity here in Minnesota. I'm here to testify on behalf of the Legalization bill and express our support. There are many aspects that we are pleased to see, such as the flexibility with the allocation of generated revenue as written in Article 9, which we actually see as a gold standard for states looking to legalize cannabis. This revenue will not be a windfall and therefore should not be treated as such. So having that flexibility and the ability to reevaluate the revenue streams is an excellent start to this new market. That said, while we are overall supportive of this legislation, we do also see some areas for improvement, such as reducing overregulation. Businesses and individuals should be able to enter the market without burdensome mandates and increase costs and inhibit growth and innovation. I will also note that it is our position that the government should neither require nor prohibit employers from drug testing. I also urge legislators to carefully consider what prior convictions might pose a specific risk for licensed employment purposes. Rather than barring everyone with a criminal conviction from being involved, we recommend prohibiting types such as the illicit market. And competitiveness and stability that the Office of Cannabis Management be required to submit an annual market analysis to determine whether public hearings to consumers, market holders, and but it is equally important that the mandates are not over-prescriptive and do not go beyond what we need to establish a functioning industry, especially in its infancy. Be positioned to legalize the market with appropriate measures in place, and as we learn what works and what doesn't, then we need for additional structures. We appreciate the Senate authors for shepherding this legislation through, and we look forward to the committee process of continuing to shape this legislation. Thank you.
Thank you, Ms. Buckles. Next, I'm going to read off the names of the next two testifiers, Glenn McElfresh and Wade Lundberg. and welcome, Mr. McElfresh. Very good. If you could introduce yourself and any affiliation for the record, we look forward to your testimony.
Absolutely. Chair McEwen, committee members, and Senator Umu Verbaeten, thank you for the opportunity to speak today in front of the Senate Labor Committee on SF 73. My name is Glenn McElfresh, and I'm a co-founder of Plift, a hemp-derived beverage company. I've also led application groups in multiple highly competitive medical and adult use marijuana markets, including states that do and do not require labor peace agreements. I was raised in a union household and support labor's rights to organize and demand better working conditions and wages. However, as a small business owner with less than 5 employees, I encourage you to carve out micro business license holders and businesses with less than 10 employees from SF 73's labor peace agreement requirements. Small marijuana businesses already have enough on their plate, and they would collectively save millions in legal fees if they did not need a labor peace agreement. More importantly, removing the labor peace agreement requirement would allow small Minnesota marijuana businesses to begin operations if anyone chooses to litigate the constitutionality of labor peace agreements as written in the current version of SF 73. Federal labor law generally prohibits states from regulating labor management matters that are protected or prohibited, or even arguably protected or prohibited, under the National Labor Relations Act, as well as those matters that federal law intended to be left subject to unregulated market forces. Federal labor law requires employers and unions to bargain in good faith, but it does not require them to reach agreement. Thus, a state regulation requiring private employers to agree to contracts with unions governing their conduct in connection with labor organizing would appear to fall squarely within the broad sweep of federal preemption and, as a result, be unconstitutional. By conditioning the renewal of the marijuana license on the acceptance of the union's demands, the state effectively imposes a timeline on my union negotiations and undermines my ability to rely on my own minimal economic power to resist the strike. Congress intentionally exposed the field of labor law to the free play of economic forces when it legislated the National Labor Relations Act because it helps small businesses like mine. Minnesota is ready for adult use marijuana, but the issue I described today is one of at least 3 legitimate unconstitutional concerns in the current version of SF 73. Please address these concerns before this bill passes, or Minnesota's adult use marijuana market will be mired in litigation for years, delaying the launch of product sales and harming the very businesses it's supposed to help. Madam Chair, members, and Senator Umu Verbaeten, thank you once again for the opportunity to testify today. I'm happy to answer any questions you may have.
Thank you for your testimony. Oh, and welcome, Mr. Lundberg. If you also would introduce yourself and any affiliation you'd like for the record, we look forward to your testimony.
Sure, and thank you. Good afternoon, Chair McEwen and committee members. My name is Wade Lundberg, Political Director of Unite Here, Local 17, Minnesota's hospitality union. We represent workers throughout the industry in 26 union hotels, our major sports facilities, our convention centers, concessions and in-flight catering at MSP International, restaurants, and finally in craft brewing and the distilling industry. We're excited to see Senate File 73 in the Labor Committee today. There are many different components and moving pieces to this legislation, but today Unite Here would like to thank the legislators for including important labor provisions in the bill. Unite Here represents workers in craft brewing, and we're pleased to see new markets opening up to those same operators with the ability to manufacture THC derived from hemp products that Minnesotans are already enjoying. Workers in this newer industry are in a position to have standing in their workplace, according to how the bill has been authored. We'll work closely with the chief author and others to moving forward with any suggestions that might improve those provisions. We're also pleased to see common sense rules, regulations, and standards being hammered out this session that sets the table for success moving forward in this new market. Beyond providing for workers in Senate File 73, success will be measured by recognizing and continuing to support our small and medium-sized businesses, including BIPOC, women, and immigrant-owned enterprises that have already invested in this historically, or to see new opportunities in this growing industry. I thank you and ask you for your support today.
Thank you for your testimony. And our last testifier today is Mr. Brad Leto. Welcome to the Senate Labor Committee.
Thank you, Chair McEwen, and the members of the Labor Committee, and it's an honor to sit next to my current senator. My name is Brad Leto, and I'm the Secretary Treasurer of the Minnesota AFL-CIO, the labor movement's shared voice of more than 300,000 working people belonging to more than 1,000 local unions. And you've heard from unions at both bills today that have a representation of over 10,000 union members. I'm here on behalf of working Minnesotans as our executive passed a resolution in favor of the bill in support of Senate File 73. Senate File 73's establishment of a well-regulated adult-use cannabis market in the state will allow local communities to heal from past racially biased cannabis enforcement and all workers to reap economic benefit of this new Minnesota industry. I'll speak first on the provisions concerning the committee this morning on drug testing and employee anti-discrimination provisions, and then make some brief comments and some in response to the labor peace discussion. Although certainly Robert and Rachel were much more eloquent on that. Article 1, Section 52, Subdivision 5 places important guardrails on employers not being able to discriminate against a person in hiring, firing, or terms of employment. Yet, it restricts the use, possession, sale of cannabis or being impaired while on the work site. Likewise, Article 6, Sections 21 and through 34, I'll just say, provide necessary exceptions to a testing program and protections for employees and job applicants from discrimination and unfair treatment. Yet it takes a common sense approach by providing cannabis testing exceptions for safety-sensitive positions, first responders, those working face-to-face with children and vulnerable adults, etc. And I would just say that on those provisions, if you have further questions, 30 some years ago, and I can't remember exactly when I worked in the other body as a committee administrator for the Labor Committee, I was involved in the original drug testing language, which later the federal government used to craft some of their language. Finally, on the labor peace provisions, I'll just, obviously you heard, from the other folks here, I just think it will ensure new jobs in the industry are family sustaining and is free from labor management disruption, because labor peace actually provides form where there's no work stoppages or labor strikes. So that's an advantage. And then also I'd just say, as far as constitutionally, in other states, labor peace agreement, and in here, labor peace agreements have been upheld. So it's not a clear constitutional, can be upheld and will be upheld. And it's an effective tool to provide a fair process for cannabis workers to form and speak out about unsafe or unlawful conditions without fear of retaliation. Finally, we urge you to pass Senate File 70 today so Minnesota can establish a cannabis market that leads to high-road jobs that benefit working families and the community and provides the worker and drug testing requirements protections built into the legislation. Thank you.
Thank you for your testimony. And members, before we go to discussion, Senator Umer Verbaeten, do you have any further comments or anything further with your initial presentation of the bill? Okay. All right. Members, with that, we'll open it up to some discussion of the bill. Yes, Senator Liskey.
Thank you, Madam Chair. Madam Chair, first I'd like to start with the stance that I've taken generally is that I'm not opposed to legalization or at least decriminalization of marijuana. So that is the stance I've taken. And so at this point, I really, when I read this bill, the things that I get concerned about are the enforcement side of the equation. And so sticking to our labor discussions, we have a huge section here about when you can and when you cannot use cannabis, and when you can and when you cannot ask an employee if they are on the use of cannabis. And in this case, in the bill, it talks about how you can't use it if you're having a safety-sensitive job, but if you were to use it prior to, we have no testing to prove that they weren't using it right before they entered the work facility, or that weren't using it while they were in the work facility. So my concern here is we don't have any way of testing that. And so can you answer like what the plan is, how we plan on moving forward and using this type of thing?
Senator Umar Verbaeten, and it looks like an expert has joined us at the table. If the expert is going to address any of the questions, if you could also please identify yourself for the record before you do. Thank you.
Thank you, Madam Chair and members. My name is Layli Fadahi. I'm a campaign manager for MN is Ready. We're the state's largest and most diverse coalition of cannabis policy stakeholders. We've been working the last few months to help improve this bill substantively as it makes its way through the committees. Madam Chair, Senator, for safety-sensitive positions, drug testing is permitted for employers. So the proximity of the drug use to when somebody is working is irrelevant as a legal matter for an employer. They can drug test the same way they drug test now to see if there's any cannabis that has been consumed by that individual, and that could be a basis for employment.
Senator Liskey.
Thank you, Madam Chair. Madam Chair, again, another question to kind of follow up on that. We are now in the process, in theory, of legalizing marijuana. That means that on their own time, they are allowed to use said products. And that means that if we were to test them, say somebody enjoyed cannabis over the weekend, they're allowed to do that according to this bill. But then they show up on Monday and somebody reports that they think that the employee has been using marijuana on the job site or right outside the job site, or however you want to get into this discussion. They are now reported. Now it is the job safety, HR, it is their job to now perform this drug test. The issue is that they're still going to test positive because they just used over the weekend, and we have no way of separating those uses.
Senator or Ms. Fateh?
Madam Chair, Senator, so again, if it's a person in a safety-sensitive position, the timing of the use wouldn't make a difference. For people who are working in positions that are not safety sensitive, if there is an issue at the workplace where there is concern about their sobriety, about their safety, it's irrelevant under the law whether they are under the influence of cannabis or something else. An employer can take action on the basis that that person has shown up to work impaired or creating a safety issue. Nothing about this changes that. The only thing that changes is that the bill says that the fact that somebody used cannabis when they're not on the job, and if they come to work and there's no issue with their performance and they're not in a safety-sensitive position, the fact that on their own time they used cannabis is not a valid reason to fire that person, as is the case with alcohol. And that's codified in existing law.
Senator Liskey, follow-up.
Yes. So I guess, again, we're kind of entering into this. I get where you're coming from. Again, employees that are not in safety-sensitive employment, such as police officers, firefighters, doctors, things of that nature. It still brings up my questions, or at least, let's go back to those individuals. They have the right to use the product when they're not working. And let's say they're on a month-long vacation. There is a long time they have off. They can use this at the, let's say, middle of their vacation. Now they come back to work. For some reason, someone that either A, works with them, doesn't like them, or B, let's say a firefighter gets reported by somebody, they say, oh, they were stumbling around. Well, maybe they were stumbling because the object they were trying to move was heavy. But you still have the question of safety because an accident can happen. Now they get drug tested, they test positive. What kind of ramifications does this have on them? Are you saying that they're now not allowed to use it on their time off, on their vacation? That's what I'm concerned by.
After you.
Madam Chair, Senator, no, what I'm saying is that the employer would still be able to take action, fire that employee if they are not doing their job, if they're not doing their job safely, if they are stumbling for whatever reason. The fact that that person used cannabis on their free time has no bearing on that. And that's the case now as well. If an employee shows up, they could be under the influence of any number of things. And a lot of those things are not things that are drug tested for, but the employer still has the ability to fire an employee that is not able to do their job correctly.
So I'm understanding it kind of goes to job performance, right? I mean, is that accurate to say? Like, an employer could still take action if an employee shows up to work and their job performance is being affected by a perceived being intoxicated in some way, being under the influence of some sort of substance that was making their job performance less than what's expected.
Madam Chair, that is correct. There is nothing that requires that there be a positive drug test that's contemporaneous with when the person is on the job as a predicate to an employer being able to discipline or fire that employee if they're not able to carry out their work.
Thank you. And Senator Liskey, do you have follow-up?
I do. Thank you, Madam Chair. Again, like I said, my number one concern here is we are now trying to legalize cannabis use. At the same time, we're running into an issue of, well, they used it whenever ago, they're now on the job site, the accident completely irrelevant of what happens. They could be fired due to a positive drug test that has nothing and no bearing on the accident and the workforce. That is my number one concern. You're seeing an if-then or a two separate rules being applied to two different types of employees, when in reality that employee may have had nothing to do with their cannabis use. And so that's what I'm concerned about, is because the employer then has the right to ask for that test and could fire them because the test come back positive, but it had nothing to do with the accident or nothing to do with what was happening in the workplace. So I guess that's what I'm trying to get to. But going on from that, we get back into the discussion of how are they getting fired? Why are they getting fired? What's the location? That kind of thing. And that's just the point I'm trying to make. So I guess that's where I'm at. Thank you.
Thank you, Senator Liskey. Do you have any follow-up or response, Senator or Ms. Fatehi?
Madam Chair, Senator, this is an issue that has been a topic of discussion amongst employment attorneys, and by and large what I hear from employment attorneys is that is why employers can choose that drug testing is not part of the protocol for making a disciplinary decision like that, that it's not necessary to have that drug test, so you can choose as an employer when your employee is not in a safety-sensitive position whether you're going to test them for cannabis or not. If your concern is just the performance, then you evaluate employment based on performance, which is what the vast majority of employers do in the first place. I don't drug test my employees if they show up and they can't do their work. I don't first drug test them to find out the cause. It's irrelevant.
Good questions. Any further discussion? Yes, Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, I have an amendment to offer. It's the A89, I believe it's posted.
Okay, great. And if we could also have the A89 passed out to members, that would be great. Senator Grunhagen to the A89 amendment.
Okay, what it basically does, it says that, the people who sell the cannabis, the business owners, they do not have to have a union. It's their, it's their choice, rather than where we mandate that they have to have a union. I think that's consistent with what we see in the private sector, not only in our state, but across the nation. The other thing the amendment does, it says that just a minute, Madam Chair. it takes away what the amendment does, it takes away the right of the union to strike if they're employed by a cannabis distributor. I think of hospitals, which are much more critical than pot sales, or I served on education for about 16 years, and we had the right for teachers to strike. And so I think, now I could divide the amendment if the would support one part or not the other, but so basically it gives the union the right to strike if it's a union employees, and the second part it does is it also takes away that it has to be union as far as the employees, and I think that addresses some of the concern of smaller employers testimony that we had here in relationship to this bill. So with that, I'd like to see what the response is from the senator.
Senator Umer Verbaeten.
Thank you, Madam Chair. Senator Gruenhagen. I would encourage members to vote against this amendment. We saw this amendment in the Commerce Committee, and I think our testifiers really spoke to the benefits of these labor peace agreements. So I would just encourage you to vote it down.
Okay. Yeah, Senator Wiesenberg to the A89. Well, I'll go to you afterward, sure. Any further discussion or comment on the A89? Yes, Senator Gruenhagen.
Yeah, members, I just think it's a reasonable amendment, and it gives a little bit of flexibility versus requirements. Again, from a union standpoint, we allow nurses to strike, and obviously their responsibility is critical. And we also allow teachers to strike, and yet it's critical as far as the education of our children. So I think this is a step in the right direction versus the mandate that we see inside of this bill. So I'd ask you to support the amendment.
Thank you, Senator Gruenhagen. And I'm just going to make a quick comment, and if you'd like a follow-up after, I'll give you that. Okay. I don't. The bill doesn't do that. The bill does. A labor peace agreement is not making an industry a union industry, although I would love to see this industry be entirely union. That's my own personal belief. But a labor peace agreement puts some parameters on both an employer and on a union. Also, it limits the activities that a union can engage in and workers can engage in. So what it does, it's exactly what it is, what the title describes as a union peace agreement. So there's an agreement on the part of the employer and an agreement on the part of the union to not engage in certain things so that the business can continue on. And that if employees do decide to unionize, that they are then, they have an understanding that the employer will not interfere with the employee's decision as to whether or not, and they may decide not to. But I just wanted to make sure that that was clear and stated in the record. And with that, Senator Gruenhagen, if you have any follow-up.
Oh, thank you, Madam Chair. Yeah, well, according to my staff input, they do think it requires union employees as far as the pot sales. And if it doesn't, then this amendment could just go on because it just reinforces what you just got done saying. And so I would encourage a yes vote on the amendment.
Okay, we have a motion to add the A89 amendment to Senate File 73. All in favor of adding the A9 amendment, please say aye.
Aye.
All opposed, say nay.
Nay.
Nay. The amendment does not pass. Further discussion, and I think I had Senator Wiesenberg next in queue, but I could.
Yeah, go ahead.
Okay, Senator Wiesenberg.
Thank you, Madam Chair. I have discussed this bill with many proponents of this and tried to work on language in it to not harm people who are currently in this industry. Now, I know this is a bill to legalize adult use of marijuana, so I'm still struggling to understand why hemp is included in the bill. I would think it could be removed. But anyway, I know that hemp is mentioned like some 360 odd times, and marijuana is less than 100, I believe. So I guess one question would be, do you know how this would harm any family hemp farmers? Thank you.
Senator Umar Vervaeten or Ms. Fatehi?
Thank you, Madam Chair. Senator, there are forthcoming amendments coming to the bill that address this issue for our hemp businesses. And what they do is set up a separate licensing structure for those businesses that are dealing exclusively on the hemp side rather than the full adult use size. As you know, some of the testifiers you've heard in this committee and prior have spoken to, the crux of the issue with mixing the two is that hemp is a federally compliant product, as are the hemp-derived products, and so the businesses that are engaged in either manufacturing or selling or growing the hemp products, if they are able to maintain some of the federal tax benefits that everybody that is not in the cannabis industry has. And so this is something we've been aware of. We've been working with stakeholders. The authors have been extremely engaged, and so you'll see solutions to those forthcoming.
Thank
Senator
you.
Wiesenberg.
Yeah, thank you, Madam Chair. And I do have a follow-up, maybe a question or just statement, but I know obviously with any farming, if you have cows or pigs or corn or whatever, and if you're a hemp farmer and you have children on your farm, they're probably helping with some aspect of this, whether it's watering or anything. I do believe the bill says anyone under the age of 21 can't work in this industry. Now, is that going to be addressed? So if, say Bob has a kid who's 18 and wants to help on their parents' farm, I think that, people have kids and they help with the family business. I think that should be acceptable. Thank you.
And thank you, Senator Wiesenberg. Any comment or follow-up, Senator or Ms. Fatehi?
Thank you, Madam Chair. Senator, this is an issue that is on our radar, and we'll work with the authors and with AG to navigate it.
Thank you. We'll stay tuned.
Okay,
Senator
thank you, Madam Chair.
Wiesenberg,
So
yeah.
it does sound like we're going to work on doing that. Okay, thank you. Okay.
Yep, good question. Yes, Senator Greenhagen.
Oh, thank you, Madam Chair. Yeah, I just have a statement. I do not favor recreational marijuana. You maybe guessed that already. But, I did 13 years of prison ministry or jail ministry, and I've seen the exhaust of addiction and exploitation of people. And the people who made a lot of money off it don't show up at the jail to visit those people, by the way. But, when you desert the Judeo-Christian principles this country was founded on, which promote respect and care for each other, we slide down a slippery slope of licentious freedom. And that's what this is. It's a freedom to exploit and addict each other and make financial money off of it. And in my opinion, that's not in the Constitution. And this is just one more step to addict and exploit your fellow human being and even young people and make a lot of money off of it. It doesn't get rid of it illegal, and I sincerely wish you would withdraw this bill and that we promote things that actually support freedom and liberty and respect and care for each other rather than exploitation and addiction. Thank you, Madam Chair.
Members, any further discussion? Yes, Senator Dornick.
Thank you, Madam Chair. Again, thanks to the testifiers. I appreciate you coming. Thank you, Senator Umar Vervaeten. I know that we're always looking at the things that our goals, many of our times our goals are the same. My number one goal in this is public safety and workplace safety, and I'm sure that's yours too, a big concern. And my concern is at this time we have no test. I'm wondering how close are we to have a test that we can find the results like we could with DWI or a case like that. So that would be my first question.
Madam
Senator.
Chair. Thank you, Senator. I just want to make sure I can clarify the question, and I'll probably ask Ms. Fateh to chime in, but are you asking about tests in terms of road safety?
Well, that
Senator
would be
Dornick?
one, but workplace safety, so that we can tell if there's an accident or if someone, I can just give you a quick example, actually, well, two, but I'll just give you one. When I worked on the job site, I had a couple guys I could tell that they were high. I have enough experience I could tell. But I could turn them in, but I'm just saying like in that instance that there's a, hey, pull them aside and say, hey, the employees or employer wants to do a test and then see the results, fairly quickly. And yes, it would be a roadside test too, to be able to use it then too. But we're talking about labor, so it'd be on the job site.
Senator Umer Verbatim or Ms. Fateh?
Thank you, Madam Chair. Senator Dornick, this is something that I think, by and large, in all states, legal or not, is something that there is an interest in developing because we do want to keep people that are under the influence of cannabis off the roads. And in other situations, they shouldn't be under the influence. In terms of how long it's going to take, it is something that is under development, and actually this bill creates a pilot project to work on developing exactly that kind of a roadside testing instrument pilot project that's written into the bill.
Senator.
A pilot program, which means they're working on it, so do they have an estimate or not yet at this time?
Ms. Fateh.
Madam Chair, Senator Dornick, I know that there is work being done in a number of places to develop such technology. I would be happy to follow up with some literature about that. I don't know off the top of my head with sufficient confidence to testify to the specifics.
Thank you.
Senator
Madam Chair,
Dornick.
follow up, yeah. So do we have data from other states on, and maybe you can follow up with this after to the workplace safety and roadway safety and how that's working in other states, but more specifically to the job site. Being I've been on construction sites many times, there's people running heavy equipment and also just heavy power tools and just all kinds of stuff. And when you're up, 15, 20, 30 stories and somebody drops something, it's a big deal. So just some of the safety there on the job site. Is there data available to see? I know Colorado is one state. I don't know all the states that have legalized it, but so my question would be the data for the workplace safety.
Senator or Ms. Fateh?
Madam Chair, Senator, I'd be happy to follow up with some specific studies with data on that as well. Yes, there's data on all of these issues coming out of the various different states, and by and large what they demonstrate is that there is not a significant, or there's either decline in some instances or no increase in incidents in states that have legalized, and it's largely because people are already consuming these products and engaging in exactly these kinds of behavior, these problematic behaviors and situations. And oftentimes when there's legalization, it comes hand in hand with an effort to make sure people are educated about the consequences of their driving under the influence or showing up to work specifically.
Senator Dornick.
One or two more questions to the senator. So I'm hearing a real big concern, especially from the, and also the construction community too, but have you asked and did some research on and hearing from your community as far as businesses having a concern about some of the things that I was bringing up about safety, but also the workforce shortage we have and the truck drivers already, and just that's going to put more pressure, and they're very concerned about that. So have you reached out, and what have you been hearing?
Senator Umer Verbatim.
Thank you, Madam Chair, and thank you, Senator Dornick, for the question. As one of the co-authors in the bill, I've definitely been involved, but I want to give major props to Senator Port, who's really had an open door. She's had a number of conversations with stakeholders. Door is still open to do that. And I think Ms. Fateh will be able to speak specifically to that question around truck drivers. But I know that Senator Port is very engaged and has had many, many conversations with folks.
Ms. Fateh, did you have any additional comments?
Thank you, Madam Chair. Yeah, I'd be happy to just, speak specifically to the truck driving issue. I mean, what we're understanding is the crux of the truck driver shortage issue is that the U.S. Department of Transportation, obviously, cannabis is not legal federally, and it is a requirement if you want to hold a U.S. Department of Transportation, the credentialing that you need to be able to have that kind of license, that people are opting not to do that because they would then have to drug test. And presumably, I mean, it just sounds like this is not an issue of whether it's legal or not. This is a matter of whether people are choosing to work in that industry, whether it's because of the drug test, the requirement to not consume cannabis, or some other aspect of the industry. But, like keeping something illegal at the cost of public health, et cetera, just to create a pipeline for people to be eligible for a job they otherwise wouldn't apply for, seems problematic. It also seems like it's the wrong locus to be focusing the lobbying pressure if the concern is that at the federal level, people can't drive because cannabis is federally illegal.
Senator Dornick, follow up.
Thank you, I appreciate that. So I'll just close with, so that's a big concern. I get what you're saying. I know it's a federal issue with the driving, and I concur with that. It really needs to start at the federal government. It'd be nice if they would deal with it, and they continue to kick that can down the road. So again, thank you for that. I just close with, in the condition that it's not, I can't support it, but I will reach out to Senator Port and do a one-on-one. So with that, I appreciate the information, and thank you so much. And I will just talk to Senator Port later then. Thank you.
Thank you, Senator Dornick. Okay, looks like
Madam
we're
Chair?
Yes, Senator Umer Verbatim.
Unless there's any other questions, we have a few amendments to bring forward, and I think it would be helpful to start with the technical ones, A91, A93.
Should we start with the A91? All right, we're having the A91. It's in our packets already, if people want to take a look. And Senator Umer Verbatim, if you would tell us about your amendment.
Thank you, Madam Chair. This is just a technical amendment from the Department of Labor and Industry. It adds right on line 1.8, the legal cannabis industry. It's just adding that language around the duties and goals for DLI in developing dual training programs under the bill.
Okay. Are you moving your
I'll move the
amendment?
amendment. Thank you, Madam Chair.
Thank you, Senator. Senator Umer Verbatim moves the A92 amendment. All in favor of adopting the A92, say, oh.
The A91.
Oh, I'm sorry. This is the A91. I'm sorry. I was looking at the wrong number. Senator Umer Verbatim moves the A91 amendment. Thank you for the correction. Oh, I'm sorry. Senator Liskey.
Thank you, Madam Chair. Madam Chair, Senator Umer Verbatim, you said this is just a technical amendment, but it's actually adding a pretty significant change to the bill by adding somebody into dual the dual here going on. So this isn't just like a technicality. This is adding something whole and new to this bill.
Senator Umer Verbatim. Okay, and Senator, it does sound like we have available with the Department of Labor and Industry, Dan Solomon, who could perhaps address the dual training pipeline issue. Thank you very much for joining us. If you have any reaction or comment that might enlighten us, we would appreciate it. Thank you.
Sure. Thank you, Madam Chair. Thank you, Senator. I'm Dan Solomon. I'm the manager of the Minnesota Dual Training Pipeline Program at Department of Labor and Industry. And to Senator Liskey, to address your question, the way the bill was originally drafted, it wasn't explicitly clear what industries be covered for potential training. And so the idea to add it was, Pipeline has always been able to operate under our current 4 industries, which are manufacturing, agriculture, healthcare, and IT. And the original draft of the bill had a reference to include cannabis, but it was the agency and the author's opinion that to make it explicit so that all of the other training programs that are mentioned in the bill for other industries, such as transportation, et cetera, that those could also be potentially included. And so that was the idea for the clarification to address what the author had wanted, so that all cannabis jobs could potentially be approved for new competencies and training. And we also want to thank, obviously for the additional staff person, the appropriation to be able to implement and create these new competencies and occupations. Hopefully that addresses the question.
Thank
Kupek and I were talking about this offline, but that would now include higher education as part of because this is now part of that discussion.
Is there any? Not fine, we can move
Madam
ahead.
Chair, if Council wants to. Okay.
I want to say that the bill and this to me seems like they would need to be authorized to do the activity for which they're receiving the appropriation. So in that sense, I clear up that they can do the thing the money for. And Chapter 25 is, I believe it's a labor and industry statute. I understand there's some interactions with higher ed and the dual training, but it's not amending the higher ed statute that is particular to higher ed. So, the reference to the statute, it's only changing the statute. And as far as interactions with higher ed, I guess I would leave that up to the department to address that.
Thank you.
Thank you, Madam Chair. Thank you, Senator and Council. I would obviously defer to Council on what other committees that it has to go. I know there's a provision, I think, in the bill that wasn't for discussion here for additional grant funding to the Office of Higher Ed in relation to the dual training grant, and so that might be something that for you all to. But I defer to Council as to whether or not that wasn't a provision that was being discussed. I know in